So our story is going to start with a familiar scene to most of us, which is students reciting the Pledge of Allegiance. So this is the Gobitis family from Minersville, Pennsylvania. The two children didn't want to say the Pledge of Allegiance in class, and they were suspended from school as a result of it. The family went to court, and ultimately the case went up to the U.S. Supreme Court. The majority of the Supreme Court, they actually ruled, I believe it was 8-1, that it was proper to expel these kids from school for not reciting the Pledge of Allegiance. What the majority of the court said in Gobitis is, well, good citizenship is something that comes from when everyone believes the same things. We have cohesive sentiment. We have common beliefs and common interests. In other words, freedom and good citizenship come from conformity. So, if that's what you think about schools, what are you going to do legally with this? Well, legally they said the flag salute is something that can be led in schools, and that the schools are not required to make exceptions for anybody, even if they have religious objections to doing it. So what then happened is there was another case challenging this West Virginia law that I told you about. And some of the members of the Supreme Court changed their mind, and now it came out in the other direction, that yes, the schools must not punish students who opt out of the Pledge of Allegiance. They said, we're educating them for citizenship, and that means we need to treat them like citizens when they're in school. If we have a sort of totalitarian school and we say to students, you're living a free society, you must do this, then the students are going to think this is hypocrisy. Well, so if that's what you think a school is, the legal principles that are going to follow from that is, yes, you do have to give exceptions for people. And this is a very famous quote that comes from this case that lawyers and judges use all the time. Basically, no official can prescribe what is orthodox in politics, and you can't force people to confess their faith. It needs to be left to individual judgments. Well, let's fast forward a few years. The next big case that the U.S. Supreme Court dealt with involved protests against the Vietnam War. The young woman there is Mary Beth Tinker from Des Moines, Iowa, and her mother. She and some of her friends were protesting against the Vietnam War, and the school board found out that they were planning this protest and that they were going to wear black armbands. And the school board was terrified about this, and so they passed a rule that said nobody's allowed to wear black armbands. If you do wear a black armband, you will be suspended, and you can only come back to school if you take the armband off. Here, the court as it existed in 1969 was very similar view of education that the court had in the Barnett case. They said, in order to be good citizens, you have to have wide exposure to a robust exchange of ideas. So the legal rule that came as a result of this view, first of all, they reiterated students are persons under the Constitution. In order to punish speech by a student that happens at school, the school must show that there's a serious problem with the speech. And they really emphasized that and sort of undifferentiated fear. They said, well, gee, this black armband, that might be a problem, that the kids might get into fights over the black armbands. That's not good enough. You have to have some real evidence that the student's speech is going to cause some real problems. Well, let's fast forward a few years to a case that actually arose here in the state of Washington, the Bethel School District, which is, I believe, in Thurston County. There was a student named Matthew Fraser who was giving a speech. There was a school assembly, and his speech was a little bit different than what the school had in mind. He made some double entendres there about how this nominee is firm in his beliefs, and he pounds it in, and he doesn't do things in little spurts. He'll go to the climax. Okay, so what's the legal principle you get from this? Right. If there's basically a rule that results from the Bethel case that a school can punish vulgar speech and lewd conduct, and that doing this is in order to protect children, especially if they're in a captive audience. So now let's fast forward to this latest case from 2007. Here is the famous banner. What was happening here is actually the high schools in Juneau, Alaska, and the Olympic torch going to the Winter Olympics in Salt Lake City happened to run down the street where the school was. Finally, the torch runs by. Joseph Frederick was the name of the student, and what he and his friends had decided earlier in the week is that they just wanted to do something to sort of shake things up. They wanted to do something that was sort of funny and a little bit outrageous and maybe surreal and get on TV. Now, when he was asked later, well, what does Bong Hits for Jesus mean exactly? You know, a bong is something you smoke marijuana out of, and Jesus is Jesus, and what does this mean? And again, he said, it doesn't really mean anything. It's just supposed to be funny. And the Chief Justice was sort of forced to admit that the message on the banner was cryptic. But what she said when the case went to court, and the school board was behind her in this, is they said, if we allow the students to say things that are the opposite of what we're teaching in class, everything will be a terrible failure. And that was a pretty extreme position for the school board to take. I mean, they didn't try to say, oh, it was disruptive. They didn't try to say, oh, you know, this is not proper adult behavior. You know, telling dirty jokes at a school assembly, that's really not proper behavior. But this was a sporting event. Of course it's proper behavior to wave crazy banners around and try to get on TV. You know, that's what we do. So anyway, when this case came to the Supreme Court, what did they say about school? Well, I'm actually going to start by telling you what Justice Clarence Thomas said. He didn't write the majority opinion, but he wrote a separate concurring opinion. They said, look, early schools were not places for freedom of speech. In the earliest schools, the teachers commanded and the students obeyed. All right? That's what the Constitution is all about. And he says the First Amendment does not protect student speech in public schools. He actually says, I think the Tinker decision was wrong. And what about the majority? This was something that was actually written by Justice Roberts, who's a fairly new Chief Justice. And compared to all of these other cases that we've been talking about, there was almost no discussion at all about what the purpose of education was. You know, they basically said the students can punish students for speech that can reasonably be regarded as encouraging drug use. Because again, there was this debate in this case about, like, what does Bong Hits for Jesus actually mean? And he says, well, it might mean that he's encouraging you to smoke marijuana, and so they can punish you because that's what it might mean. So I wanted to leave you with a question, which is basically we've got throughout recent history, 20th century up to today, there are definitely two strains of thought amongst our Supreme Court justices about what school is for. There's school is supposed to turn out people who hold certain beliefs versus school is supposed to turn out people who have the freedom to choose their own beliefs. And depending on what the justices think the answer to that question is, that will affect the rules that we all have to live under. Now, the justices, where do they get their ideas about what makes a good school? They're just members of society. Now, and so in order to sort of convince our judges that we want our schools to look a certain way, you basically need to try to get more of a consensus among society as a whole of what kind of schools we want, and that will eventually trickle upwards into our decision makers.